Hi, I want to talk you through answering a Rylands versus Fletcher AO2 scenario question. I've chosen this topic because students aren't always very confident with it. And the truth is, I don't think it's a very difficult topic, it's just not that exciting. When you're used to learning about murder and manslaughter, an ancient land tort from 1868 might not be as interesting in comparison. However, stick with it. Rylands is actually quite a short, straightforward topic, and answering a scenario question on it as a result is quite a straightforward process if you understand that process. So what I wanted to go through was some of the key things from the Rylands versus Fletcher summary and just how to shape those in a scenario question. And what we'll do is we'll have a look at an example question as we go through the video, and you can see what I mean in practice. So just a reminder, the things that you are looking for is that you have 25 marks to achieve in approximately 30 minutes. 10 of those marks are for your relevant AO1 knowledge. Now, because Rylands versus Fletcher is so short, most of it will end up being relevant. You also have 15 marks available for your AO2, and that assessment objective is how well you apply your knowledge to the given scenario. So where do we start when it comes to an essay? The first thing that I would do is read through the scenario and start highlighting the key information that you think is going to be important. So for example, who do you think the claimants and defendants are? Is there any signs that we are dealing with something that is dangerous, unusual? What damage has actually been suffered? Once you have that information in your head, you can start to actually write your essay. So the things on this side of the board are my AO1, my knowledge and understanding of the topic. And the things on here generally remain the same for any Rylands scenario or essay question. So it's really well worth trying to memorise the things that are on this board. So where should we start in an essay or scenario? I think it's really useful to do all the AO1 first, and please in the exam feel free to write a heading of AO1. Show the examiner very clearly that that's what you're doing. Now, it's really important at this stage that we don't refer to any of the people or events in the scenario. The reason for that is because the examiner will automatically start giving you AO2 credit, so you'll bypass these 10 marks available, and that's not what we want. So at the moment, we're just giving generic legal information. Always start with your definition. A lot of students struggle with how to start an essay. Don't do anything fancy, just Rylands versus Fletcher is. So Rylands versus Fletcher is a land-based tort that is seen as an offshoot of nuisance law. It comes from the case of the same name, Rylands versus Fletcher, all the way back in 1868. Now, if you can remember the sort of rough general definition, that gives you your essay plan. What I've tried to do is give 9 key points that we're going to turn into questions to make a note of in our AO2. So we have 9 points plus our definition, which gives us neatly 10 things to remember for the exam. In order to get excellent AO1, we also need to have plenty of supporting case examples. There is no maximum or minimum really. It all depends on what the rest of the students are putting in there. So for example, if you only include 2 cases, that isn't going to be as strong as someone who puts in 5. I've included some of my favourite case examples here, some ones that I think are quite common and can crop up again and again. But don't feel like you've got to learn all of these and this is the right amount. I don't mean that by any means. But as a good rule of thumb, I've tried to make sure that most of the key points have a key case to back it up. So you first off need to define proprietary interest, and that's where you own or rent the land. Then the defendant has been defined as the person who is in control over the land or the thing that's on the land. That person must have accumulated a thing that's a non-natural use of land. So explain the term accumulated. Accumulated means that the defendant has brought and stored it on the land. It's not something that naturally is found there or naturally grows. And actually, Rylands versus Fletcher is a great case example of this, because this involved a reservoir. Now, of course, things like puddles are naturally occurring and therefore wouldn't be an accumulation. However, with a reservoir, we specifically dig the hole to try and hold and accumulate the water. It also has to be a non-natural use of land, and this was specifically added in by Lord Cairns in the House of Lords in this case. And non-natural, don't get confused with this meaning from number 3. What we mean here is not ordinary. So think of a kind of almost witchy, unnatural sense of things. So it's not an ordinary use of land, and there's been a lot of case examples to help with this. I quite like Transco as a modern example, where it talked about water pipes being quite a common use of people's land. Remember, the aim of Rylands versus Fletcher is to make people accountable for anything they have on their land through industrialisation. It's not to punish ordinary people for doing normal things. Next, it must be likely to cause mischief. Now, mischief is just the ye olde 1868 word for damage. So was the thing likely to cause mischief? It doesn't have to be inherently dangerous. Shiftment is a great example of that with a flagpole. A flagpole is not inherently dangerous, but of course, if it falls, if it escapes, it's likely to cause mischief. By escape, there has to be movement, a sense of movement. So it goes from the defendant's land onto the claimant's land. Reed versus Lyons failed because the claimant was injured in the defendant's factory. Could be a negligence claim, won't be Rylands. We've had the recent development of Stannard versus Gore in 2012 that has looked at the circumstances surrounding fire. Remember, fire is usually the thing that escapes, but it has to be the dangerous thing that escapes. So in LMS versus LMS with the polystyrene stayed where it was, but the fire spread. That would not work as a Rylands claim, because the polystyrene was the thing that was brought and accumulated. The fiery polystyrene would have to be the thing that escaped, and that obviously didn't happen. Remoteness of damage is used as a test here. This is just the test from the wagon mound case, which we're familiar with from negligence, and it's just asking whether the damage was reasonably foreseeable. And they were talking about this in Cambridge water, whether poisoning the water supply was foreseeable, and the courts felt it wasn't in that particular case. Damage is now property only. That was confirmed in the case of Transco. So it can't be personal injury, can't be purely economic loss. Finally, talk about the defences. So there's a few others like contributory negligence, valenti, but the two main ones to talk about are the act of God or act of nature, and act of a stranger or act of a third party, as we'd use in more modern terms. Good case example for that would be Nichols versus Marsland, which had the most terrible thunderstorm that had ever been reported on. That has to be the sort of terrible intervening act we're looking for. So you should spend about 10 minutes making a note of this, and I would literally write it almost in sentences. Just take out the numbers, write the sentences. And what I've done is I've underlined the 10 key terms that will hopefully, if you remember those, you'll remember the structure of the essay. Define, proprietary, control, accumulation, non-natural, likely escape, remoteness, damage, defences. Remember those 10 words and your essay is straightforward. Once you've written that, we are then going to use those questions, those definitions as a checklist for our AO2. All right, so what do we have to look at here? So you have 15 marks available. That doesn't necessarily translate to 15 ticks. 15 marks is just the maximum available for excellent AO2. So this is where we need to draw on the facts given. So don't be afraid to use quotes from the actual scenario itself. As a rule of thumb, in real life, Rylands versus Fletcher claims are incredibly hard to win at. So if you find that your claimant is succeeding, just maybe take a second review and double check. The aim of AO2 is to conclude, based on the facts, whether there will be a successful claim in Rylands versus Fletcher. Now there may be potentially 2 or 3 incidents going on. Some of these you can combine. So for example, questions 1 and 2, you might be able to do all in one. So first thing you need to check is who is the claimant, who is the person who has suffered, and first off, do they actually own or rent the property to have a proprietary interest? If not, it could potentially be a claim in negligence instead. Now, if at any point you think the answer is they don't, the claim fails, don't just stop writing there. Continue anyway, but just remember it'll fail at the end. Then identify who is the defendant, who is the person being sued. Do you feel that they had control? Was it their land? Was it their business, for example? Now, I've just put in as a separate point here. Now stop and check what the thing is that you're actually looking at in that incident. What is the thing that has essentially caused the trouble? Is it rocks? Is it a water supply? Is it chemicals? Next, check, were they brought and accumulated there for the defendant's own benefit? In other words, it's not something that's naturally occurring, it's something that I've actually physically brought. Remember, that can include a sink, because when you turn the tap, you bring the water there. When you've checked that, you need to decide if it's a non-natural use of land, and that just means you're asking the question, does it seem ordinary and normal for the person to have that there? There's a few pointers that you might use to draw that conclusion. Location is an important one. So if it seems really out of place, so for example, lots of tyres on a residential estate is probably quite unusual, then it's probably non-natural and you can continue. Also look at quantities. Anything that you have lots and lots of is likely to be non-natural. So for example, you might have a bottle of hair dye in the house, natural, but if you have gallons of it in drums in your backyard, that is non-natural. Although it sounds strange, we tend to compare it to a domestic setting. So straight away, that means a lot of factories and businesses might be seen as non-natural, even if it's ordinary to have it. So in the case of Cambridge Water, it was normal for a tannery to have drums of chemicals, but it was still classed as non-natural because it's not something we would tend to have in our own backyards. Finally, it's something that we judge based on modern times. So Musgrove versus Pandelis, a car in a garage was seen as non-natural, whereas now that probably would be natural. If it's a natural, ordinary use of land, then it's an acceptable thing and it won't be a Rylands claim. Once you've determined that, do you think it was likely to cause mischief if it escaped? That should be a fairly straightforward question. Do you think if it escaped, even if it's not very probable that it would, so for example, it's not very probable that a flagpole will suddenly fall down, even if it's not very probable, if it did happen, would it cause damage if it did? So for example, water would clearly be likely to cause mischief or damage if it escaped. It would clearly flood and cause damage. And then check it actually did escape. Did it move from the defendant's land to the claimant's land? And remember, with fire is probably not the thing. So for example, if it's tyres catching fire or wiring catching fire, the tyres or wiring is the thing and those did not escape. It is the fire that did, so the claim would fail. However, if the fire is the thing, so perhaps we're looking at a fire in a fireplace or fireworks, if they have escaped, you can continue. Then ask yourself, was the type of damage that occurred foreseeable? So look at the end point here. You don't have to predict exactly how it would happen, but could you imagine that thing getting damaged by that thing? So could you foresee it happening? So for example, flood damage. Could you see water damaging X? Could you see chemicals damaging plants? You don't have to foresee exactly how the chemicals are going to get into the plants, but would you foresee that damage occurring? And just check it's property damage. Remember, and the examiners like to trip you up with this, if someone's hurt, can't claim under Rylands, it might be negligence instead. Last but definitely not least is checking for defences, and there is often an element of a defence in there. So if you think that there is a potential intervening act of nature to blame this on instead, just check that it is extremely terrible and unforeseeable. Nichols versus Marsland, worst thunderstorm ever. A little bit of rain won't do. It has to be something really, really terrible and unforeseeable to let the defendant off the hook. If there is another person involved that we might blame, check that that other person is actually a stranger and not in the defendant's control. So for example, is it vandals that have broken in, or children from a rival school, or things like that? If it's someone within your control, you should have controlled them. So for example, if it is your child doing something naughty, you should have controlled them. All of that should lead you to your conclusion. And it's really useful to suggest a potential claim in nuisance or negligence instead if you think that's appropriate. If you remember those 10 points on the previous whiteboard, it's simply a case of going back through those 10 points and then asking the questions based on the scenario. Hope that helps. Thanks for watching.